Nazism and American Legal Culture. The questions that must be addressed are not just about American and Anglophone white supremacy. There are also questions about the pragmatic American style of common law jurisprudence that Freisler touted to his Nazi colleagues as one that would suit us perfectly. The allure of American race law was not just the allure of a Nordic continental empire dedicated to white supremacy. It was also the allure of an open-ended, flexible American common law approach to the law. It was the allure of American realism, an approach to the law that was prevalent among leading Nazi lawyers, just as it was among leading lawyers of the New Deal. Not least, it was the allure of the kind of American willingness to innovate that continues to make us global leaders in many areas of the law today, just as it made us the leaders in eugenics and race legislation a century ago. What attracted Nazi lawyers was not just American racism, but American legal culture, and that means that we must face some uncomfortable questions about the value of the American way of doing things. Some of the most striking and inescapable questions have to do with the common law tradition. What Freisler admired about American law is manifestly the same thing that we often celebrate in the common law tradition today: the common law's flexibility and open-endedness, and the adaptability to changing societal requirements that its judge-centered, precedent-based approach is often said to permit. Other Nazis, too, had admiring things to say about American judge-made common law, which, they declared, had facilitated the creation of a healthy law that emerged out of the folk, rather than being the product of barren legal formalism. What should we think about this? The question is especially pressing because it has become so commonplace in America these days to celebrate the common law as superior, and superior precisely because it is thought to embody what Friedrich Hayek, the great Austrian champion of free markets and a man shut out from his home country by Nazism, called the Constitution of Liberty. American authors today frequently contrast the liberty-oriented virtues of the common law with the defects of the code-based civil law tradition of Continental Europe, which they view as overly rigid, a system in which the law is reduced to the comparatively inflexible commands of a powerful state. Here is how a leading American law professor explains why, of the two, the common law is today so widely regarded as embodying superior values. Hayek provides the most prominent discussion of differences between legal families. He argues vigorously that the English legal tradition, the common law, is superior to the French, the civil law, not because of substantive differences in legal rules, but because of differing assumptions about the roles of the individual and the state. In general, Hayek believed that the common law was associated with fewer government restrictions on economic and other liberties. These views are correct as a matter of legal history. The comparative freedom of the common law judge on this account is the institutional expression of a grander culture of common law liberty, to be contrasted with the comparative subjection of the citizens of Continental Europe and the comparative unfreedom of the civil law jurist, bound to follow the positive commands of the state embodied in the code. Common law judicial authority is a bulwark against excessive state power. This conception of the common law is not always articulated with perfect clarity, but it seems fair to say that it is broadly, if vaguely, embraced in America today. Indeed, it occupies a place somewhere in the core of our understanding of the nature of American liberty. It certainly leaves one wondering why any Nazis would ever have anything good to say about the American common law. At the same time, there is a widespread belief that Nazism was facilitated by precisely the sort of state-heavy positivism that Hayek feared and denounced. To be a Nazi, it is assumed, was to submit unconditionally to the will of the Führer, surrendering all powers of independent judgment. It was to have a law without liberty. The Nazi philosophy of law on this view was a crass version of what philosophers call legal positivism. It was a philosophy that reduced law to the bare command of the sovereign or dictator. It was a philosophy of subservience and obedience, and the lessons of the crimes of Nazism is a lesson about the dangers of state-heavy positivistic approaches which threaten, at the limit, to reduce all of society to serfdom. Yet the history that I have recounted in this book suggests clearly enough that something more complicated was going on. And so it was. In fact, careful students of Nazism have demonstrated that the legal philosophy that prevailed under Hitler was not a philosophy of crass legal positivism at all. What the Nazis espoused was something much closer to what Freisler espoused. It was something close to common law pragmatism, and if there are jurisprudential lessons to be learned from the crimes of Nazism, they are not lessons in any simple way about the dangers of crass legal positivism or of civil law attitudes. For the striking truth is that Nazi jurists were opposed to any theory of the law that reduced it to mere obedience. Yes, it is the case that Germany was to be ruled by the Führerprinzip, the doctrine of obedience to the leader, but while it is true that ordinary citizens were to be blindly obedient, Nazi officials were expected to take a different attitude. Nazi teachings on this score can be found, for example, in an early version of the Oath to Adolf Hitler from 1934, produced by his right-hand man, Rudolf Hess. According to the oath, while ordinary Germans were to swear to obey the commands of the Führer unconditionally, political leaders were enjoined to be loyal to the spirit of Hitler. Whatever you do, always ask, how would the Führer act in accordance with the image you have of him? This was a formula for a real discretion in pursuing Nazi goals. As Ian Kershaw puts it, officials were to work towards the Führer. Yes, it is the case that the Nazis vested limitless power in the centralized organization of a fascist state, but they rejected the idea that the officials who wielded that authority should be mere foot soldiers, deprived of individual initiative. If they denied the liberty of the ordinary German citizen, they frequently insisted on a kind of liberty for the individual Nazi official to act independently in the spirit of Hitler. That is indeed a part of what made Nazism so terrifying. And yes, it is the case that Nazism emerged in a continental Europe with a code-based civil law tradition, but it would be utterly mistaken to imagine that the Nazis embraced or embodied that civil law tradition. On the contrary, the critical truth of legal history is that the Nazis set out to smash the traditional juristic attitudes of the civil law jurist. Far from representing the traditions of the legalistic state, the Nazis belonged to a culture of contempt for the ways continental lawyers had been trained to work. Nazi radicals understood themselves to be, in the words of Hans Frank's greeting to the 45 lawyers who gathered on the SS Europa in September 1935, a movement that opposed the outdated type of jurist, always inclined to ignore the realities of life, and that meant that they were steadfastly opposed to the traditions of the civil law as they had existed in Germany before the Nazi takeover of the German state. We see the resulting conflict playing itself out in the June 5, 1934 meeting. Franz Goethner, Bernhard Lösner, Hans von Donani, and the other advocates of relative moderation in the persecution of the Jews represented precisely the outdated type of jurist that radicals like Freisler were determined to shoulder aside. And if we are to understand the jurisprudential drama of the clash at the meeting and the appeal of the American common law approach for a man like Freisler, it is imperative that we describe their attitudes with more care and sympathy than a Friedrich Hayek could muster. As we have seen, these civil law jurists were men who thought of the law as a science. That science had established a body of basic rules that set real limits on what jurists, or for that matter, legislators, could do. Legislators could no more ignore the logical dictates of legal science than they could repeal the laws of gravity or mathematics. The radical Nazi program of the Prussian Memorandum in particular could not be coherently incorporated into the edifice of criminal law, and for that reason it had to be rejected, or at the very least, drastically modified. This avowedly scientific attitude is the true mark of the well-trained jurist in the civil law tradition. It is certainly different from the attitude of the common law judge, but it is not an attitude of meek submissiveness to the state. On the contrary, we can think of this juristic commitment to the science of the law as imposing quasi-constitutional limits on any radical legislative program. The traditions of legal science constituted, as it were, the code in which legislation had to be written. The consequence, even as late as the early summer of 1934, was that the scientifically informed legal profession was in a position to ride herd on the demands of Nazi radicals, much though those radicals might push for political or primitive rather than scientific decisions. Yes, the state in the civil law world was in principle comparatively powerful, but the traditions of legal science operated to keep it in check. A man like Freisler was drawn to American jurisprudence precisely because it was not hobbled by this sort of outdated respect for legal science and juristic tradition, and that ought to be enough to raise doubts in our minds about whether common law liberty offers the best defense against tyranny of the Nazi kind. Common law America attracted Roland Freisler because, in his Nazi eyes, ours was a country that enjoyed the blessings of liberty from the straitjacket of formalistic legal science, and by German standards, he was right. America was and is a country where belief that there are scientific principles of the law that impose limits on what politics can do has always been comparatively weak. Trained legal scientists have never wielded the kind of power in America that Gertner and Lösner were still able to wield in early June 1934. To be sure, Americans have certainly sometimes cultivated something that they have called legal science, and the American version of legal science has certainly sometimes imposed limits on the legislative process. In the late 19th and early 20th centuries in particular, self-described American legal scientists dominated institutions like the Harvard Law School. During the same period, the Supreme Court developed its own legal science, founded in the Due Process Clause of the 14th Amendment, which it used to strike down progressive economic legislation, most famously in the 1905 case Lochner v. New York. To some extent, American lawyers of what is commonly called the Lochner era aspired to claim the same authority that German legal scientists like Gertner and Lösner aspired to claim. But if Americans sometimes liked to speak of their legal science, the reality is that American legal science was always a far weaker force than German legal science. The doctrinal legal science of American law schools was never a match for the subtlety and systematic depth of its German counterpart. As for the Lochner-era courts, while they sometimes struck down economic legislation, they also left much progressive legislative untouched. More importantly, they left racist legislation almost entirely untouched as well. When it came to race, American legal science generally yielded unceremoniously to American politics. As for American common law judges, unlike German legal scientists, such as Lösner, they showed no sign of concern about the conceptual incoherence of their racist decisions. Where Lösner insisted that criminalization was at best problematic in the absence of a scientifically defensible definition of a Jew, American common law judges, as Freisler approvingly noted, simply improvised their conceptions of coloreds as they went along. That was the racist America that commanded the respect of radical Nazi lawyers. It was an America where politics was comparatively unencumbered by law. The great jurisprudential conflict at work in Nazi Germany was not the conflict between common law liberty and civil law state power. The great conflict was between lawfulness as founded in a civil law idea of legal science and a lawlessness in favor of which a man like Freisler could invoke the American common law. Nazi law, as a man like Freisler imagined it, was not a crass form of legal positivism, reducing the law to a duty of obedience to the command of the superiors. Nazi law was law that was liberated from the juristic past. It was law that would free the judges, legislators, and party bosses of Nazi Germany from the shackles of inherited conceptions of justice, allowing them to work toward the realization of the racist goals of the regime with a sense of their duty to use their discretion in the spirit of Adolf Hitler. Judges in particular were to enjoy meaningful independence to be exercised in line with the goals of the Führer. By this means, the law would institutionalize and perpetuate a savage form of national revolution by giving discretion to the savage instincts of innumerable Hitlers in innumerable state offices. It would create a Nazi Hydra. That is precisely how Freisler conducted himself in office as president of the People's Court. And that was why the jurisprudence of common law, with its pragmatism, its immediacy, its surrender of lawmaking authority to the judges, attracted him so much. It is in light of the same issues, finally, that we should think about the nature of 1930s realism. It is a large part of the story that throughout the 1930s, leading lawyers in both Nazi Germany and New Deal America were self-proclaimed realists, equally committed in both countries to combating the outdated type of jurist, always inclined to ignore the realities of life. On the American side, this was the high age of the movement called American legal realism, which has long been described as one of the great products of an American pragmatic style, ready to tackle social problems in a can-do spirit and displaying a healthy resistance to dogmatism. Such realism, for its American supporters, was sharply opposed to formalism, a style that produced a rigid kind of pseudo-scientific law unable to adapt to the modern social needs. The association between this American legal realism and the New Deal is close indeed, and American lawyers often express considerable pride in their realist tradition, the most important indigenous jurisprudential movement in the United States, as Brian Leiter writes, during the 20th century. Meanwhile, the economic programs of the early New Deal were undertaken in a closely related pragmatic spirit. As Franklin Roosevelt described the American mood in a famous 1932 speech, the country demands bold, persistent experimentation. The epic legal drama of the early 1930s, retold in every history of the New Deal, was the drama of the conflict between the bold experimenters of the administration and a hostile Supreme Court. Jack Balkin describes how the lawyers of the 1930s viewed this struggle. On one side, there was a conservative Supreme Court with its history of striking down at least some progressive economic legislation on formalistic grounds. On the other side was New Deal pragmatism oriented toward social realities. During the Lochner era, courts employed a rigid formalism that neglected social realities, while the New Deal engaged in a vigorous pragmatism that was keenly attuned to social and economic change. The Lochner-era court imposed laissez-faire conservative values through its interpretations of national power and the Due Process Clause, while the New Deal brought flexible and pragmatic notions of national power that were necessary to protect the public interest. The conservative Supreme Court famously continued to block the key reforms of the New Deal until the momentous switch in time of 1937, which at last put the court behind the administration's program. This epic struggle between executive and judiciary, like other aspects of the New Deal, was followed in the Nazi literature, and Nazi authors saw it in the same terms that American realists did. The battle was precisely a test of whether the bold experiments of New Deal politics could overcome outdated legalistic conceptions of the dictates of the Constitution in favor of the necessary realistic action in the face of economic crisis. As one Nazi commentator put it, The Supreme Court's decisions striking down the programs of the early New Deal were incomprehensibly formalistic and alien to life. Meanwhile, on the German side, anti-formalistic approaches dominated in Nazi writings during the same years as well, though Nazis did not use the term realism as frequently or consistently as Americans did. The Nazi jurists who participated would be among the most influential in Germany throughout the 20th century, though after the war all of them made determined efforts to suppress the record of their Nazi activities. Today there is little national German pride in that country's 1930s Nazi realism. Nevertheless, there was indeed something it is reasonable to call 1930s Nazi realism, and it was a vigorous movement. And it is a striking fact that when scholars set out to describe the jurisprudence of both the United States and Nazi Germany, they arrive at formulas that are almost identical. The American legal realists, we read, were driven by the perception that law and life were out of sync. In just the same way, we read that for the Nazis, the great aim was to overcome the alienation between life and law. Life law before formal law is the fundamental drive of National Socialist legal life, as one Nazi put it. Bringing law back in line with life and social realities was the watchword on both sides of the Atlantic in these troubled years. So what precisely was the connection between the two realisms, Nazi and New Deal? Certainly in the 1930s, there were plenty of observers who thought the affinities were close. As G. Edward White has written, throughout the decade the American legal realists had to struggle with the perceived relationship between their moral relativism and the rise of amoral totalitarian governments. In April 1934, for example, Carl Llewellyn, the leading voice of American legal realism, was told that "you have been accepted as a true Nazi, fit to be amalgamated in the lifeblood of the new Reich." Llewellyn, who was an energetically committed liberal, responded with real anger, but he was not the only figure who had to navigate the ugly associations of realism in the 1930s. Another noteworthy example is Hans Morgenthau, the pioneer of realism in international relations. Morgenthau had begun his career as a young lawyer in Germany, where he had imbibed the most advanced German legal thought of the Weimar Republic. With the coming of Hitler in the 1930s, though, he fled abroad, and as a freshly arrived exile in America, he decided he had to avoid the term realism, as his biographer writes, because he worried that it might encourage American readers to place him in the camp of American legal realism, or even worse, to infer an association with Nazi ideologues who were also advocating a realistic view of the law. It was not until after World War II that Morgenthau was willing to advocate realism again. An odor of Nazism was clinging to our most important indigenous jurisprudential movement in the early 1930s. That certainly does not mean that the American legal realists were Nazi sympathizers. Most of them unquestionably were not. The realists were not in reality fascists any more than FDR was in reality a dictator. The fact that there was a Nazi variant of realism certainly does not imply that we must recoil in horror from everything in our own tradition. The American legal realist movement yielded some superb insights, from which there is still much to learn in my view. Moreover, there is a case to be made that it was the American legal realism of the New Deal era that eventually set the stage for Brown v. Board of Education in the 1950s. In any case, whatever resemblances there may have been, the fact remains that the Nazi courts descended into appalling depths of lawlessness. Even at their worst, American courts were better. Nevertheless, for all that, there were unmistakable resemblances between New Deal realism and Nazi realism, and we cannot properly assess Nazi interest in American race law and the Nazi sense of kinship with the United States in the early years of the Hitler regime unless we make some effort to grapple with them. There was more to realism in New Deal America and Nazi Germany than I can explore here. The topic requires a book of its own. Here I would like to emphasize only the obvious point. The realists of both countries shared the same eagerness to smash the obstacles that formalistic legal science put in the way of life and politics, and life in both New Deal America and Nazi Germany did not include only economic programs designed to lift the two countries out of the Depression. Life also involved racism. It is here that the affinities between the realisms of Nazi Germany and New Deal America should really begin to make us shift uneasily in our seats. American legal realism was not just the possession of liberals like Carl Llewellyn. There were also many prominent American racists of the 1930s who embraced it. The realistic attitude in American law did not just involve yielding to political decision-makers when it came to economic legislation. It also involved yielding to political decision-makers when it came to racist legislation. And while some prominent realists spoke out against American racism during the 1930s, most passed over the race question in silence. In that sense, the American legal realism of the early 1930s was entirely at home in the early New Deal, founded as it was on the Mephistophelian bargain between economic reformers and Southern racists. The same realistic legal philosophy that could be invoked to defend the bold economic experiments of FDR could also be invoked to defend the racism of the Southern Democratic Party. Such was the American scene in the early years of Hitler's regime, as it presented itself to the eyes of German lawyers. America was a country that united economic reform in the face of the Great Depression with racism. The racist side of it was perceptively described by Heinrich Krieger, the former exchange student at the University of Arkansas Law School, whose work made its way into the hands of the Ministry of Justice officials planning the Blood Law, the German lawyer whose research did the most to shape Nazi understandings of America. Krieger saw that the deep tension in American race law was no different from the deep tension in American economic law. As he put it, the United States was a country torn between the two shaping forces of formalism and realism. When it came to race in particular, there was, on the one hand, the formalistic jurisprudence of the 14th Amendment, with its commitment so alien to life to the equality of all human beings, and on the other hand, the realistic racism of a law that was rooted in the legal intuitions of the American folk, and that had produced the ingenious, devious pathways of second-class citizenship law alongside the frank racism of anti-miscegenation statutes. Krieger did not think that this American state of affairs was healthy. He believed that America was struggling to be open about its legal racism, as it ought to be, but that it had not yet managed to do so. Nevertheless, he remained hopeful that the United States might achieve full health once it finally abandoned its formalism in favor of its realism. One Southern racist published a 1938 review of Krieger's book that communicated his hopes for America perfectly. Race law in the United States, wrote the reviewer, was a scholarly and valuable study informed by Krieger's realism. The Nazi Krieger was a frank man facing the problem squarely, and he made a powerful case for reviving the racial exclusionism of his heroes, Jefferson and Lincoln. Krieger is convinced by his studies, and he will convince any sincere reader as well, that our race problems can be solved only after we have found our way back to the point of view held by our greatest statesmen. That was a realistic point of view, and it alone can lead to a healthy and fair solution for all races concerned. Such was the realistic point of view that Heinrich Krieger carried home from Fayetteville to Nazi Germany. Perhaps it goes without saying that all this should give us a bit of pause when it comes to American legal culture with its pragmatic traditions and the vaunted openness and adaptability of its common law. Sometimes the American common law may indeed produce superior results with its comparatively underdeveloped attachment to legal science, its experimental quality, and its liberal grant of authority to judges. American contract law, for example, is, in my view, exemplary in its innovativeness. Sometimes the American democratic political process produces admirable legislation. But to have a common law system like that of America is to have a system in which the traditions of the law do indeed have little power to ride herd on the demands of the politicians, and when the politics is bad, the law can be very bad indeed. The resulting dangers have not vanished, and it would be wrong to close this book without pointing to at least one contemporary realm of American law in which they are still making themselves felt. That realm is American criminal justice. American criminal justice is spectacularly and frighteningly harsh by international standards. It includes practices that are sometimes uncomfortably reminiscent of those introduced by the Nazis. For example, 3 strikes and you're out laws, a form of habitual offender sentencing. The Nazis, too, promoted habitual offender sentencing. What makes contemporary America so exceptionally harsh? The answer, in part, is that contemporary American criminal law is unique in the advanced economic world in the extent to which it is shaped by the political process, whether through tough-on-crime legislation or through the election of judges and prosecutors, a practice unheard of in the rest of the world. Conversely, American legal science has proven uniquely incapable of staving off the dangers of the politicization of criminal law over the past generation. American jurists do not have the influence to put the brakes on the projects of politicians who make their careers on tough-on-crime platforms. Post-Nazi Continental Europe, where the traditions of legal science have reasserted themselves powerfully, is different in this regard. In Continental Europe today, the legal profession generally manages to keep a steady hand on the criminal justice system. Not so in the United States. What Roland Freisler saw and admired in American race law 80 years ago is still with us in the politics of American criminal justice, as is, not least, the American race problem that looms so large in it. The story in this book, in that sense, is not done yet. There is currently one state, wrote Adolf Hitler, that has made at least the weak beginnings of a better order. When one thinks of race law, said Nazi lawyer and later SS Obersturmbannführer Fritz Grau, one thinks of North America. It is attractive to seek foreign models, declares Reich Minister of Justice Franz Gertner, and like others before them, it was American models that the lawyers of the ministry found. To be sure, America had failed to target the Jews so far, as Heinrich Krieger acknowledged. But apart from that exception, declared Roland Freisler, hanging judge of the National Socialist People's Court, America had things to teach Germany. The United States had produced an admirably uninhibited racist jurisprudence, a jurisprudence that did not trouble itself about juristic niceties and that would therefore suit us perfectly. In the eyes of these Nazis, the United States was indeed the classic example. It was the country that produced the really interesting innovations, the natural first place to turn for anybody in the business of planning a race state. That is why the National Socialist Handbook of Law and Legislation could close its chapter on how to build a race state by describing America as the country that had achieved the fundamental recognition of the truths of racism and taken the first necessary steps, now to be carried to fulfillment by Nazi Germany. Yes, of course, it is also true that the United States was and remains the pioneer of many magnificent legal institutions. Of course, there were also many aspects of the liberal democratic tradition in America that the Nazis found contemptible. Of course, America proved a generous place of refuge for at least some of the victims of Nazism. Nevertheless, when it came to race law, numerous Nazi lawyers regarded America as the prime exemplar, and, much though we may wish to deny it, it was not outlandish for them to think of their program of the early 1930s as a more thoroughgoing and rigorous realization of American approaches toward blacks, Asians, Native Americans, Filipinos, Puerto Ricans, and others. Even if the regime had shifted its sights to a new target in the form of the Jews, even if it would later take the racist exercise of modern state power in an unimaginably horrifying new direction. This, too, has to be part of our national narrative.